Welcome to Landlord Training, the only business that people get into with no knowledge or training whatsoever. The city of Milwaukee offers this course to help keep illegal and destructive activity out of rental property because landlords are gatekeepers. You get to decide who's going to live on that block where other people are trying to raise their children. So please follow the rules and do your job. This is me, Property Management Program Coordinator for the city of Milwaukee. My name is Mark Medrick. I was born and raised here. I remember when Milwaukee used to be the cleanest, safest, best managed city in America by a mile. I actually remember people slowing down for yellow lights. It's true. I was there. Things have changed. Now everybody and their mom is trying to be a landlord. So as I mentioned, the city offers this program to try and help you do a good job at it because you have a responsibility to the other people living up and down the block. So let me give you a little background on myself. I've been a landlord on and off for 22 years in September. And I've given one 5-day notice in that entire time. I can tell you that I rented to a person who lost her house, her husband, and her job in the same week. I don't necessarily recommend that as a as a business model, but I did, and I paid the price for it. But at any rate, I know what it feels like to not get paid, and then to have my tenants avoid me, and to have to clean up and store their stuff, and even have to fix damage to the property after the person who owes me money left, right? I mention that because that is sometimes a thing that the landlords have to deal with, or those are things that landlords have to deal with. And I think it just comes with the territory, but you can help minimize that. And this course will try and help guide you through that so you can hopefully avoid that sort of stuff. I was also a tenant on and off for probably 15 years in North Carolina, Wisconsin, all over the Milwaukee area. And I remember the last place I lived in before I bought my house, it was a converted mansion. And I lived there with 3 roommates that were not related to me by birth or marriage. Let me just say that is not legal, landlord. If you have tenants that are not related by birth or marriage, and engaged to be married is not related yet, unless that property is zoned as a rooming house, that is illegal. And if it is zoned as a rooming house, you're going to have fire extinguishers on every floor. You're going to get an annual fire inspection, and the bedrooms are going to have deadbolts on there. True story. So lived in that property where we were paying 4-digit rent in the late 90s already. And our front steps were uneven and treads were loose. My mom and my stepmom both tripped on the front steps. We had water that would come in at the chimney because the flashing was bad and the roof was in kind of bad shape. And nothing ever got fixed, but our rent went up every year. That is not uncommon. Please don't be that guy. Just said all that to say I know what that feels like too. And I've also been on and off before taking this position. I was a residential inspector in Milwaukee, first on the south side, then 53206 neighborhood, and then in 53211, 212. So if you can picture I-43 to the Milwaukee River and about Townsend Keefe down to Commerce Street. Yes, and I learned a few things. Among them, I have 3 rules of talking to people in the city of Milwaukee. If you're taking notes, you might want to jot these down. Maintain eye contact when you're talking to people, because those of you that went to public school like I did, you know that if somebody doesn't maintain eye contact when they're talking to you, you assume one of 2 things, that they're either scared or trying to pull something over on you. And neither one of those helps the conversation, landlord. So maintain eye contact when you're talking to your tenants or neighbors or whomever. Rule number 2, and this one's tough, this is a gut check. Acknowledge other people's truths. If you're coming to collect your rent and your tenant says, hey, I don't have all of it, I'll have the rest of it in a few days. And you say, oh, come on, that's the second time in like 3 months you told me that. And if they come back with, in the same 3 months, I've been asking you to fix that leaky faucet in the bathroom. What I suggest you do is, if it's true, acknowledge their truth. You're right. I have been telling you I was going to fix that leaky faucet and I haven't. Because what you do when you do that is that you create parity. You have shown your tenants in a very real way that you're not just interested in collecting the rent money, that you're also interested in making sure that their needs are met and that they have a decent place to live. That goes a long way, landlord. There are a lot of tenants out there who don't feel like their landlords care, and consequently, they don't care much for their landlord or their interests either, and nobody wins. So Maintain eye contact, acknowledge other people's truths. And rule number 3 is, if you can, involve tenants in the process. If the neighbors are complaining that your tenants' guests are hanging out in the backyard after they're done visiting, at all hours of the night, and they're disturbing the neighbors, if it's true, talk to them about it. Say, hey, what can we do about your friends hanging out in the backyard and disturbing the neighbors? Because the neighbors have contacted me. I will just mention that neighbors can be free property managers. You want to cultivate that relationship. But I digress. If your tenants' friends are parking in other people's parking spaces or using storage facilities that they're not privileged to use, starting the conversation with, hey, what can we do about, is a great door opener and allows the tenants to be part of the solution, because nobody likes to be dictated to. Yes, you can use a 5-hour notice, or I'm sorry, a 5-day notice, and say, hey, look, this has got to stop in 5 days or else. But just having a verbal conversation of, hey, what can we do about, helps build a relationship with the tenants, and hopefully you won't need to use written notices in the future. So those are my 3 rules of talking to people in the city of Milwaukee, and I hope they work as well for you as they did for me. So without further ado, let's dig into this program. It is a community effort to fight drug houses and requires the cooperation of neighbors, homeowners, tenants, and businesses. That includes you, landlord. I'm aware that many landlords in the city of Milwaukee do not live in the city of Milwaukee. As unfortunate as that may be, you can still have a mindset of being part of that community. You can still have your heart and spend some time in the place there when you don't have to. By that, I mean, be there sometimes for no reason other than to just drive by and see what's going on at your property, right? If you're there during decent hours in common areas on official business, you don't need a 12-hour notice. You need a notice or permission or an appointment or an emergency to enter into the tenant's private dwelling units, but to just be at the property, you do not need permission or a 12-hour notice. It just has to be during decent hours and on official business. So do that sometimes. Point number 2, police, community liaisons, crime prevention, drug and vice. Regardless of what your feelings are or experiences are with the police, recognize that they are there when you are not at your property, and they help keep your property value up. So it doesn't help anybody to not have a good working relationship with the police. It's not show friends, it's show business, right? So make sure you have a good working relationship with the police where you have rental property. And then lastly, owners, landlords, and property managers. Not everybody is cut out to be a landlord. But Mark, didn't you just say that everybody's trying to buy rental property? Yes, it is probably the hottest investment right now in America. Just look around at all the apartment buildings that are popping up in your city too. Not everybody's cut out for the landlord business, and here's what I mean. Not everybody can approach their tenant and say, hey, who is that gentleman that I see who shows up at 8 or 9 p.m. at night, and then he leaves at 6:30 in the morning, and I don't have him on the rental agreement? Because I've seen him do that about a dozen times now. If you can't have that conversation without getting angry, without getting upset, without your tone of voice changing or your voice getting loud, maybe you want to consider hiring a property manager. Because as I mentioned, not everybody is cut out for this business, even though the money is good. Assistance for landlords in Wisconsin, there is a lot. It's not so new anymore, but it's still relatively new. The Rental Housing Resource Center is an organization. It's an umbrella organization housed in the Community Advocates Building on James Lavelle Street, in between Wisconsin and Wells, in downtown Milwaukee. If you have an issue that is not a 911 emergency, that should be your first contact. There's the phone number. There is also that web page, renthelpmke.org. When you enter that into your address bar, it'll ask if you're a landlord or a tenant, and it'll ask a few more questions, and it'll sort of pre-screen you and send you in the right direction. Rental Housing Resource Center has lots of resources at your disposal. I'm a member. The Apartment Association, well, formerly known as Apartment Association, now called the Rental Property Association, in other words, the Landlord Association, their members, Legal Aid, Legal Action, Mediate Milwaukee, Impact Connect, Social Development Commission. There are all kinds of organizations under one roof, so to speak, there to help landlords and tenants solve their issues. Notice it mentions even if you're going to get rid of tenants, you still want to contact the Rental Housing Resource Center to help those tenants relocate. They can navigate to a new place. Rental Property Association, as I mentioned, good idea if you're new to being a landlord, become a member of the Rental Property Association. You will be surrounded by people that are dealing with the same issues you are. You'll be rubbing elbows with people that not only have tenant situations that are similar to yours that they have dealt with in the past, but you'll be dealing with professionals in all aspects of rental property. You have real estate people, insurance people, pest exterminator people, roofers, towing companies. I don't know how many of you under the sound of my voice know, but there is a special process for towing an abandoned vehicle on your rental property. You cannot just have it immediately towed. You must stick a sticker on the window first and give 2 days for that person to respond to it. If you don't know that, you, the landlord, could get in trouble for somebody else abandoning a vehicle on your property. True story. Department of Neighborhood Services. I like to sum up the Department of Neighborhood Services like this. We keep people safe, healthy, and alive. Yes, neighborhood services is mostly made up of inspectors and other people like that, right? That are involved in various aspects of housing and things involved with your buildings. But recognize they're not out there to hurt people. We are there to keep people safe, healthy, and alive. And if orders are issued against your property, know this. Inspectors, whether they be plumbing, electrical, construction, boiler, residential, commercial, whatever kind of inspector, they only enforce minimum code standards. So don't take it personally. They're just letting you know, hey, you're not meeting the minimum, and somebody needs to say something about it. Housing Authority. There is the City of Milwaukee and Milwaukee County Housing Authority. They're separate entities. And they provide, among other things, rent assistance. They will provide up to 100% of a tenant's rent. Yes, up to 100%. But know this, landlord. First, they're going to come and take a look at your property to make sure that you're meeting the minimum code standards. That doors have deadbolts, that windows have sash locks on them, that you have smoke and carbon monoxide alarms where they're required. True story. They will also make sure that you are charging reasonable rent for that area. Now, it's going to be reasonable based on what other people are charging, which doesn't necessarily mean reasonable, but just know this, that if you are too far out of bounds for what other people are charging for a similar unit in that area, they might not take that case and that you might not get the rent assistance that your tenant is applying for. So be aware of that. Charging reasonable rent is in yours and everybody's best interest. Judges, public and private attorneys. I cannot give you legal advice. The only person that can give you legal advice is an attorney. You might be able to get it from a judge, but typically they don't get involved in that stuff. But know that if you have a situation in context, you have a tenant who's doing blank. If you ask somebody for advice on how to handle that, technically that is considered legal advice. Even if you don't think of it as legal advice, somebody giving you procedural advice on how to deal with a landlord-tenant situation is by definition legal advice. So ask somebody who knows, ask an attorney who knows landlord-tenant law. Wisconsin has the most comprehensive landlord-tenant laws of any state in the union. Next, landlords, managers, and screening companies. I hope I made the point that not everybody is cut out to be a property manager or a landlord. So consider wisely. Also, screening companies are a great benefit. I have heard landlords say that the #1 determiner of whether somebody is going to enjoy their rental property is how well they screen their tenants. Because if the money that they're making on the rental property comes attached to all kinds of trouble, be it police or neighbors or the tenants or other tenants, at some point the money loses its value, right? How well you screen your tenants is really going to determine how much peace and quiet and how much enjoyment you get out of your rental property. So screen wisely. If you'd rather have somebody else do it, go that route. Metropolitan Milwaukee Fair Housing Council is an entity there to guide you in what is allowed. they can coach you on people's rights, because housing rights and discrimination are a huge issue in America right now. You as a landlord cannot just claim ignorance. Oh, I didn't know that I was breaking the law. You are still culpable. So if you have a question about something that you want to do, a screening requirement or a procedure that you have, whether or not that's allowed, pick up the phone and call the Metropolitan Milwaukee Fair Housing Council and find out if you can, because you're better safe than sorry. Now, as I mentioned, Wisconsin has very detailed and sorry, I blanked there. Milwaukee has very detailed housing codes and rental codes and statutes. One of them being ATCP 134.08. Now, ATCP 134 stands for Wisconsin Agriculture Trade and Consumer Protection Division, Chapter 134, which is called Residential Rental Properties. Residential rental property means single families and duplexes only. So if it's a 4-family, or if it's a bowling alley with apartments upstairs, or if it's a 16-unit building, that does not fall under ATCP 134. But the state of Wisconsin has 10 illegal lease clauses. The first one is, if you try and unduly raise a tenant's rent, or if you curtail their services because they contacted neighborhood services about conditions at the property, that is considered retaliation. And ATCP 134 says that if your rental agreement says you can do that without penalty, that is an illegal lease clause. And according to ATCP 134, as you read in red, a rental agreement that contains those provisions is void. It says, notwithstanding state statute 704.02, which you see conveniently located for you down below, that a rental provision or a rental agreement is void and unenforceable if it does any of the following. And it goes on to list those 10 illegal lease clauses, one of which I mentioned, that you cannot retaliate against your tenant because they contacted neighborhood services about conditions at the property being substandard. That is illegal in the state of Wisconsin, even if the tenant agrees to it, that you can raise their rent or take away their parking or their laundry or their storage privileges. Now, state statute 704.02 talks about severability, or line item removal, if you will. That if any provision of a rental agreement is rendered void or unenforceable by reason of any statute, rule, regulation, or judicial order, the invalidity or unenforceability of that provision does not affect the rest. In other words, if you have something wrong in your rental agreement, only the wrong part gets crossed out. Everything else is still in force, according to state statute 704.02. I juxtapose these because how would you know which one is right? One of them says the entire rental agreement gets tossed out. The other one says only the wrong language gets crossed out. How would you know? Well, one way is to read the entirety of state statute 704, which incidentally is called rental properties, and it applies to all rental properties, whether they be 3 families, 5 families, 16 family, mixed use commercial and residential. As I mentioned before, state statute 704 applies to all of them. And they also list those 10 illegal lease clauses, this being the first one, that you cannot, your residential rental agreement is void and unenforceable if it does any of the following: allows you to punish the tenant for contacting law enforcement services, health services, or safety services. You just can't do it. But a lot of people don't know this, so we have conveniently offered it for you here in our program. Part 1, prepare. Prepare the property. Why? You can attract better tenants that way. Providing a quality product at a reasonable price will attract you better tenants. Then 2, screen them. There's no shortcut around screening. If you want trouble, just don't screen your tenants. You will find trouble, or it will find you. And number 3, enforce rental agreements. There's a saying, it's not show friends, it's show business. That applies. Enforcing your rental agreements does not make you a bad person, depending on how you do it. If you just remind your tenants, hey, line 43 of your rental agreement says, for example, you're not allowed to move in a tenant without my express written permission. If the tenant has done so, Just notifying them that they have broken the rule is enforcing the rental agreement. It's letting them know, hey, we have a situation and there's an array of ways we can deal with this going forward. You choose. Lastly, maintain and manage your property. You never earn the right to not maintain your property. I've spoken to landlords when I was an inspector who tried to convince me that they had been so ill-treated as landlords that they no longer had to maintain their property to minimum code standards. There is no such legislation that supports that. If you own property, you have a civic duty to maintain it to the minimum code requirements, period. Here's a nice quote I pulled from a landlord meeting where this landlord said, since we put in the lights, we've had less crime. So landlord, sometimes spending a little bit of money, doing a little bit of preventative maintenance at your property will pay large dividends in peace and quiet. Preparing your property, maintain it to habitability standards. As I mentioned, I am not aware of any sort of statute or administrative code that precludes a landlord from maintaining their property. If you own it, you must maintain it. Keep it looking clean. You will attract better tenants that way. If there's vandalism, repair it. If there's graffiti, please report it. And by that we mean take a picture of it, go to the local police station and say, hey, look, this is the graffiti that I found on my garage or side of my house or whatever, and then remove it, paint over it, preferably while it's still wet. Because painting over it while it's still wet is probably going to discourage people from coming back and doing more graffiti on your property. Crime prevention through environmental design means apply a little bit of thought, a little bit of forethought, a little bit of planning when you're looking at your rental property. Would lighting or video surveillance curtail people from doing naughtiness or cutting through your yard or doing whatever? Keeping bushes trimmed so people can't spy on your tenants in their bedrooms or whatever. Consider putting up a fence. It's a deterrent to people walking through your yard. Post a no loitering sign. I don't know how many of you knew, but without a visible no loitering sign, even if people are obviously loitering at your property, the police cannot issue a ticket unless there's a visible no loitering sign. So that's on you, landlord. Put up a no loitering sign, and it's not going to take too long or too many tickets before people find someplace else to loiter. Address numbers must be clearly posted on a property. And if you have an alley and or a garage, they must be clearly posted on the back of the house as well, or on the back of the garage, clearly visible from the public way. Before renting, ATCP 134, as I mentioned earlier, applies to single families and duplexes. If you have rental agreements and other paperwork that a tenant is required to sign, those regulations established in writing shall be furnished to a prospective tenant for their inspection. It doesn't just say viewing. If you have a complex, multi-page rental agreement, perhaps drafted by a lawyer, that the average person can't understand what they're reading, they have the right to take that to someone that can explain to them what they're about to sign before they actually sign it. And before a rental agreement is entered into, and please notice, before any earnest money or security deposit is accepted from that prospective tenant. Yes, they have the right to know what they're getting themselves into before you get to touch the money or before they enter into a rental agreement. And they shall be given a copy at the time of the agreement. When they sign that rental agreement, they should walk away with a copy right then and there. I will tell you in a moment why this is so important, even though some of you may be thinking, Mark, I'm aware that this is violated frequently. Promises to repair. Likewise, every promise or representation made by a landlord to a tenant or prospective tenant that something about the unit's going to be cleaned, repaired, or otherwise improved, it shall specify the date or time period on or within which that's going to take place. Please also notice that all promises made before the initial rental agreement shall be in writing with a copy furnished to the tenant. Now, the reason why this slide and the last slide are so important is because if you ever find yourself in eviction court trying to evict a tenant for something other than non-payment of rent, a tenant being evicted for non-payment of rent can only save themselves by either stipulating an agreement or proving that they paid the rent. Otherwise, there's no other sort of leverage that they have. However, if you try and evict a tenant for something other than non-payment of rent, and the tenant in eviction court can prove that you broke the rules also, For instance, they didn't let you see or even understand what the rental agreement was before they signed it, or before the rental agreement was entered into and money changed hands, or if you made promises to fix, clean, repair, or provide things that you did not put in writing, that provides that tenant leverage. They very well might get out of that eviction, even though they were wrong of doing something themselves. You did something wrong, they did something wrong, it'll get thrown out of court, most likely. Property condition inspection sheet. That's in chapter 704 of the state statutes. In other words, it's a law. A check-in, check-out sheet is required by law in the state of Wisconsin. The tenant has at least a week, including a weekend, to fill that out and to notice things that might be wrong, with their rental property, and put them in writing for you. Be aware of that. You might also consider a residence handbook. It's information that your tenants can follow. Explaining things like, the rental agreement says rent is due on or by the 1st. A late fee will be charged if it's paid after the 5th. Oftentimes, tenants will understand that to mean that my rent is due somewhere between the 1st and the 5th when I can actually get charged for it. I would make it clear to my tenants that that's not what it says, that your rent is still due by the 1st. I can't charge you a late fee until after the 5th, but I can give you a 5-day notice on the 2nd or the 3rd or the 4th. Also, there is a Wisconsin Guide for Landlords and Tenants. If you do an internet search for Wisconsin Guide for Landlords and Tenants, there is a multi-page manual, sort of a mini landlord tenant training program, that tells you what Wisconsin says is required of the landlord and of tenants. It's a good idea. Knowledge is power. You can put your expectations down. Again, as I mentioned, let tenants know that rent is due on or by the 1st, or at the very least, you better let me know ahead of time. You might add things like bacon grease does not go down the kitchen sink. These are the sorts of things that come up often. You might want to emphasize the point that somebody's spending the night more than 14 non-consecutive nights, or if you get your rental agreement from Wisconsin Legal Blank, it'll say 3 nights in a row or 14 non-consecutive nights in any year. That person is an occupant and you may be in breach of your rental agreement. There are also many internet resources that can help you supplement your residence handbook. The point is, you want to put your thoughts in writing so your tenants understand where you're coming from, and then enforce those. Because if you have a tenant sign something and then you don't enforce it, what you're really saying is, I'm not really paying attention. So what to have ready? Check-in, check-out sheets. If your house is built before 1978, you are required by law to provide a lead disclosure statement. That is a document that you sign stating all the lead you are aware of in the property. You are also required to provide each unit with a Protect Your Family from Lead in Your Home brochure. True story. Smoke and CO detector notices. Be advised, since October 1st of 2017, yes, almost 6 years ago, all battery-operated smoke alarms shall be powered with a 10-year or more non-removable battery. If you have a 9-volt battery powering your battery-operated smoke alarm, you're wrong. Now, if you have a 9-volt battery backup and an electronic smoke alarms are all interconnected. If you have electronic smoke alarms, the entire building is going to be wired together. So if one goes off, they all go off. They are allowed to have a 9-volt backup. But if the 9-volt battery is the only power source for your smoke alarm, you're wrong. You must get a 10-year sealed battery type. You also might consider adding a clause to your lease that smoke alarms are to be checked annually, because somebody needs to, either you or your tenant. Lead pipe update. Milwaukee Code of Ordinances 225-22.5 indicates that if the city of Milwaukee is going to replace its lead service line, in other words, from the center of the street where the fresh water comes to your neighborhood to what we call the curtilage, the grass in between the curb and the sidewalk, that is the city's portion. If the city's going to replace its portion of lead pipe, for whatever reason, you are required to replace yours also. Yours is from the curtilage to the house and inside the house. Just be aware, whether by plan or by emergency, if the city says to replace your lead pipes, you have to replace your lead pipes. Dangerous dogs. People involved in illegal and destructive activity often like to have a Rottweiler or a pit bull that is trained to be aggressive around the property because less people ask questions and snoop around and whatever. Because of that, the city of Milwaukee has a Rottweiler pit bull ordinance. You may see in red there, we have a brochure in English and in Spanish that outlines the requirements of having a Rottweiler or a pit bull or a variation thereof. A, the owner needs to go take a course. B, the dog must be licensed. And C, there must be a fenced-in area sufficient to contain the animal. If the dog is a digger or a climber, you might need a kennel. Just saying, oops, I didn't know is not going to work. Also, it says check your insurance policy. By that, we mean be careful that your insurance language does not preclude you of coverage or from coverage if you allow one of these dogs to be at your property and then it goes and hurts someone. Because if the dog was at your property and then it goes and bites someone, they're probably going to sue the property owner of where the dog started. So be aware of that. You might not be covered and it could be devastating. One of the few things that the Apartment Owners Association formerly called Apartment Owners Association, now called the Rental Property Association, one of the few things we agree on is that the benefits of conducting a thorough tenant screening far outweigh the costs associated with it. As I mentioned before, if you want trouble, just go ahead and put tenants in your rental property without screening them first. I can just about guarantee you're going to have trouble. What are the benefits? The main benefit is that it encourages self-selection. By that, I mean, when you have logical, sensible requirements in place for applicant screening, people who would do wrong at your property, in other words, people that want to do illegal or destructive activity, are probably going to notice not this person, not this property, and they leave on their own. That's what you want. That's what you want, landlord. It will attract honest tenants and it will discourage dishonest tenants. Everybody wins. Follow through with screening and uncover historical behavior. Please do your due diligence. If you don't want to get caught up in that, hire somebody to do the screening for you. There are services that will do that for you because it is sort of a headache, but you don't want to just skip over tenant screening. You must have written screening criteria of what you require and what you will not allow, what you will not tolerate. And you must put a statute of limitations on them. If you say that I won't rent to anybody who's been evicted or convicted before, you have to put an amount of years on there. Recognize that if you change your criteria, you have to keep them for at least 2 years after you have changed them. Apparently, that is the statute of limitations for somebody who wants to sue you for housing discrimination. Having those written screening criteria are a requirement, and they will protect you. Standard application letter for every adult, no exceptions. Landlords, if you allow tenants to break the rules, you are training them to break the rules. You are showing them that it's all right. So we recommend that a standard application letter for every adult in the property. If your tenant tries to move in a boyfriend or girlfriend, address it. Again, you can go start out with a 5-day notice if you want to. I recommend having a conversation first. If that doesn't work, then by all means, you still have the option of using the notice. Point 2, include the date of birth, social security number, and middle name, or at least middle initial for accuracy. What do I mean? When you are screening your tenants, you're going to want to know that middle name, middle initial to make sure you have the right person. Also, make sure you check the spelling of the name, right? Make sure you check the spelling of the name, because sometimes people will modify their spelling of their names. So when you do a criminal or a municipal background check on them, you don't find the naughtiness in their past. Social security number is in gray because you are not legally allowed to get or to require the social security number of minors. Their criminal record is not going to show up anyway, but just know that you're not legally allowed to require that of people. Rental history verified from an unbiased source. A previous landlord is a biased source. Apparently, it was once upon a time allowable to turn down an applicant based on what their landlord said, a previous landlord or a current landlord. That is no longer the case because they are biased. If you're going to turn somebody down, you have to have something very black and white and concrete and specific that says that they don't meet your qualifications. Otherwise, it could look like you are just discriminating against somebody. So make sure if you're going to turn somebody down, you have a very black and white, concrete, specific reason why. Sufficient and verifiable income. That is a good one. You may require a financial disclosure statement from every applicant. That is a document that your applicant fills out and shows all of their income and what amount, and all of their expenses in what amounts. If whatever's left over doesn't meet some multiple of the rent that you have in writing, let's say 3 times the rent, if they can't show you on paper that they have 3 times the rent in disposable income, or if they can't show you where their money comes from at all and they live in a cash world, that is a viable, reasonable reason to turn somebody down. Also, 2 pieces of ID that match. Then once you set up those requirements, the first person chronologically that meets those requirements and wants to rent from you gets to rent by law. There's no more deciding at that point. The first person that, quote unquote, hurdles the hurdles and crosses the finish line and says, hey, I want to rent, you must rent to them. Otherwise, you are discriminating, and that is not legal. You may also consider an earnest fee, not an application fee. Wisconsin does not make provision for application fees. If you do, that application fee must go either to the security deposit or up to $25 actual cost for a credit report. An out-of-state applicant doesn't get a credit report, they get a background check. If while you're holding somebody's earnest money, if they change their mind and decide they don't want to rent from you, you have a day to give them their money back. 1 day to give them all of their money back, unless you stand to lose money or you lost money. Notice, upon failure to accept the rental agreement, the landlord may withhold from the earnest payment an amount sufficient to compensate for actual costs or damages. It's not punitive. Only if you lose money do you get to withhold money from earnest money. And state statute 704.29 says you may not withhold for lost rent unless you made a reasonable effort to mitigate those losses. If that person changed their mind, you must open up that property for rent again. If you had a sign out front before, you got to put a sign out front again. If you had an ad on Craigslist, you got to put an ad on Craigslist again. You cannot just keep that person's earnest money and say, well, you changed your mind, so I'm keeping it. That is against the law. Applicants must include names, dates of birth, social security numbers, and driver's licenses. You want to know who's living at your property. Again, social security numbers from minors is not allowed. The name, date of birth, and relationship of all occupants comes into play, as I mentioned. More than 3 unrelated people living in any single dwelling unit, that's single family house or 1 apartment, is not legal unless that property is zoned as a rooming house. Past 2 landlords' names, phone numbers, and addresses. Those are reasonable requirements. If the person's 18 and just getting out of their parents' house and they don't have previous landlords of their own or a credit report of their own, you have to have some sort of contingency plan. Now, we included, you might have a parent cosign or charge twice the security deposit. That's not, we're not requiring that. You come up with your own. Come up with a legal, legitimate contingency plan, but you cannot just turn somebody down because they're not old enough to have rental history yet. Otherwise, you have just broken the law. Income information, make sure you know who and how much they make. Where do they work? Is there actually a place like that? If they have a bank reference, they don't work, but they inherited a large sum of money, fine. Have them prove to you that they have a large sum of money at some bank. Convictions for drug gangs and other threatening crimes. You must have in writing what you will accept and how long ago. Yes, you cannot just arbitrarily turn down anybody who has a criminal record. Here are the federally protected classes. This is important because if you treat somebody differently in your screening process because of their membership in one of these protected classes, because of their race, their color, their religion, their gender, their national origin, their mental or physical disability, their familial status, including pregnancy. If they're very pregnant and about to have a baby, and you're in an owner-occupied duplex and you turn them down because you don't want to hear a baby cry, you may have just broken the law. Be aware of that. Age, sexual orientation. What your pastor preaches is not legitimate in a court of law. People have rights, and the Bill of Rights allows people to be of a sexual orientation or have a lawful source of income of which you do not personally approve. Be aware of that, landlord. That can get you in huge trouble. also victims of domestic abuse or other crimes. If you do a background check on somebody and you find out that they were the victim of domestic abuse, they may show up on the system also. You must be careful how you use the data that you find on, in Wisconsin, it's CCAP, but you must be careful how you use that information to see if A, the person was guilty or non-guilty, and B, if they were actually convicted of something. If they were just arrested for something, that doesn't mean they were guilty. Be aware of that. If you turn somebody down for housing, you may have just broken the law. And for your protection, when you are going through these requirements, ask everyone, ask the same way, ask every time for your protection to preclude any sort of bias. Compare the ID to the application. Make sure that the spelling is exactly the same. By that I mean, if they substitute a Y for an I in their spelling, and it's not like that on their birth certificate or their ID card, they may be doing that to throw you off the trail because now their name won't show up. Be aware of that. That middle initial also, that is a great signifier of who you're actually dealing with, because there are many people that have the same first and last name in some cases. Be aware that that middle initial and birth date are going to help. Analyzing a credit report. A credit report is going to list a person's previous addresses. Make sure that those line up with the addresses that you have on your application. ATCP 134 and State Statute 704 both allow up to $25 actual cost for a credit report, unless the person provides you a credit report that is less than 30 days old. Then you cannot charge them for one. And if it costs you less than 25, the remainder must be returned. You cannot just pocket the rest. Out-of-state applicants get a background report. Be aware of that. You're still only allowed to charge up to $25. If you want to independently identify past landlords, this is a good idea. People that list addresses, call DNS at that number, or go to milwaukee.gov/mymilwaukeehome and look up the address and see who the city has listed as the owner. If it doesn't agree with what they have on their application, they might be lying to you, and you don't have to rent to liars. Verify income sources. We're talking about keeping illegal and destructive activity out of rental property. So make sure that they have check stubs that can validate where their money comes from. Or if they have bank statements, again, make sure that there is such a bank that exists. When calling past landlords, confirm the information live, just so people don't have time to cook up a story. And then criminal convictions, people have a right to walk away from criminal past. So you must have in writing what you will accept and what you will not accept. Here are some questions for previous landlords if you wish. I might remind you that previous landlords are biased sources. So if you turn somebody down based solely on what a biased source tells you, you may have very well just broken the law. These questions may provide a point of departure for an awkward conversation, whereby this applicant may change their mind and walk away, but actually you deciding to turn somebody down based on biased information could land you in trouble. Don't do it. Make it clear that your application will be denied if information is misrepresented. In other words, if a tenant lies to you, an example I'm thinking of, somebody once told me that they screened their tenant and the address that the tenant had listed was a gas station. Well, gas stations are not residential properties. So that is pretty certain that the person was misrepresenting information. If they were convicted of drug activity or other threatening crimes within a certain time period that you decide and put in writing. If they have a poor credit check, now a word on that. Experian, Equifax, and TransUnion are credit originating companies that are generally regarded as valid sources. They are coast to coast, which is one of the requirements Wisconsin has. And they are credit originating companies. In other words, they do their own research on the person involved. So Experian, Equifax, and TransUnion are valid sources for a credit report. Just recognize they vary by a few points. Experian might give somebody a 704 and Equifax might only give them a 700. Bear that in mind. If it's just a few points, it's probably just a discrepancy between the two different companies and their way of determining credit scores. But if it's drastically off by 80 or 100 points, then you're probably dealing with somebody who gave you a falsified credit report. Lastly, item E there, a poor reference from a previous landlord may be challenged. The tenant has the right to challenge that and say, hey, wait a minute, that's not true. So again, you could be the bad guy. If you turn down an applicant to rent based solely on a biased source, you may have just broken the law. According to the Fair Credit Reporting Act, if you turn somebody down because of their credit report, you must give the source name and address and provide that person a copy of the credit report that you used to make that decision. And then we recommend you notify them as soon as possible. Also consider an application interview. Have the person sit down and answer your questions face to face. I mention this because some people may get uncomfortable trying to make up palatable answers to your questions, and they might get up and leave out of frustration on their own. That's not on you. You putting their feet to the fire, so to speak, that is fair. Asking them the interview questions to their face is all right. And you might also consider an on-site fill-in policy or pay to play, if you want to think of it that way. That somebody, before they get a rental application from you, they must provide you either with up to $25 actual cost, whatever it costs you for credit reports, or they must give you one that is less than 30 days old. That is a valid policy, so you don't waste applications. Watch for gross inconsistencies. In other words, if somebody accidentally puts down June of 97 instead of July of 97, and their credit report indicates that they moved to the place July of 97, that seems like an honest mistake. But if there are gross inconsistencies, they might be trying to lie to you, and you don't have to tolerate that. Watch out for late Friday applicants in a hurry. That's to say, people that are willing to pay you a large sum of money, let's say $100 or $150, to just not screen them, to not look at their application too closely and let them start moving in. There's probably a reason, and it's probably not good. The last two on this slide go together. Ask the applicant, why are you looking to move? And see what their body language tells you. Observe how they look at the unit. If they don't flush a toilet or look inside of a closet or a drawer, they might not be interested in actually renting from you. They might just be interested in getting those keys and handing them off to somebody else who doesn't look good on paper, somebody with bad credit, somebody with a bad criminal history who can't rent a legitimate place on their own, and then they hand over those keys for a price. So be aware of that. Again, you wouldn't want to turn somebody down just because they didn't flush the toilet, but you might want to make notes to yourself and be aware of this, that the person doesn't seem like they actually intend to live here. Drive by their current residence. This is free country. You are allowed to drive by their current residence. And as I mentioned, you might find out that the place that they claim to live is actually a gas station. Announce your approach in ads. Make it clear that you're not one of those landlords that all you have to do is wave some money in front of my face and I give you the keys. Make that clear. Establish a 14-day guest policy. You decide. Wisconsin states that somebody spending the night 14 non-consecutive nights, obviously without permission. Now, if you have a tenant that's graduating college or something and they're going to have out-of-state guests and they're going to stay for 3 weeks and you agree to it in writing, that's one thing. But otherwise, just having long-term guests without permission, that is against the rules. And clarify the number of people living there. Know who is actually staying at your property. Ruth Bader Ginsburg put it like this: we the people. That has been the cornerstone of our Constitution, that we come to solutions and agreements together. Landlord, that is a great approach. Talk to your tenants about things. And then decide on what type of rental agreement. Lease is not an umbrella term. Rental agreement is. A lease is a specific type of rental agreement, and it has a hard start date and a hard end date. Be aware of that, because there are periodic tenancies, week to week, month to month, and year to year rental agreements also. That is not a type of lease. A lease means a rental agreement that has a specific start date and then a specific end date. So be aware of that. Month to month provides the landlord a lot of latitude to get rid of tenants involved in illegal activities because neither party needs a reason to give a 28-day notice. Be advised that 28 days means 28 days and a complete rent cycle. So in a month that has 31 days, you could serve that 28-day notice up to the 3rd, and that still allows 28 days until the end of the month if you expect that tenant out by the end of the month. Otherwise, if you serve it in the middle of a month, that 28-day clock does not start ticking until the beginning of the following month. Term lease, in other words, longer than 30 days. Most tenants are going to want a longer lease. Month to month, especially after somebody has just gone through the trouble of moving and then they find out 2 months later that you could maybe collect more rent from somebody else and you give them a 28-day notice. That is a lot of work. That is a frustrating situation. So you can attract better tenants by offering a term lease. It gives the greatest legal and financial protection to tenants who feel comfortable committing. There are various things that a tenant on a year lease is allowed to do that a month-to-month tenant is not. Like they're allowed to make minor changes to the property unless you have in writing that they are not. They are allowed to sublease to somebody else unless your lease specifically says they are not allowed to. Those are benefits that are afforded only to lease tenants, or tenants on a lease, I should say. But it is an enforceable legal contract when it's signed for 12 months. They are held responsible for 12 months of rent. Even if they decide they want to go somewhere else, you do not automatically have to let them out of their lease. They're still responsible to pay rent or come up with some sort of a contingency that you can agree with. And as I mentioned, subleasing in Wisconsin is legal for a year lease tenant unless your rental agreement expressly says no. Point out the key provisions. Make it clear. No illegal activities are allowed at the property. Outside maintenance must be in writing who that falls on, you or the tenant. Make that very clear. And no subleasing, no exceptions. Make that clear also. Otherwise, they may be allowed. And if there's no stipulation about late fees, you may not charge them. By that I mean, if you don't have a written rental agreement, state of Wisconsin says that in order for a late fee to be valid, it must be on a separate sheet of paper from the rental agreement. It's considered a non-standard rental provision. And it must be in writing, right? So those are the two requirements. If you don't have a stipulation about late fees on a separate sheet of paper from the rental agreement, you are charging illegal late fees. And only those on the actual agreement may occupy. Here's an example of a non-standard rental provisions form. Notice the first one is late fee. There are also others. I can tell you that this was just updated 2 months ago. Wisconsin Attorney General decided that charging punitive fees for people that break these rules is no longer allowed. That a landlord may only charge a tenant sufficient to cover their actual costs or to pay them for having to go through the trouble of separating trash from recyclables or whatever, the return check stop payment fee. Landlord may only recoup what it actually costs him or her or them. You cannot just charge arbitrarily penalties on top of that. Normal wear and tear. In the state of Wisconsin, landlords are not allowed to charge for, I'll take a look at that first note. For example, a landlord may not withhold from a tenant's security deposit for routine painting or carpet cleaning where there is no unusual damage caused by tenant abuse. So, if you have a rental agreement that says you are going to arbitrarily take X amount of money out of the tenant's security deposit for carpet cleaning when they leave, you may very well be in violation of the law. I've added this in here. As an inspector, I couldn't tell you how many landlords that I encountered who felt like they had earned the right because of the abuse that they have suffered as landlords, that they had the right to no longer maintain their property. I don't find any statute or administrative code that supports that. If you own the property, you are still required to maintain that property to the minimum code standards. Not to mention, if you only do the minimum, your tenants are going to do the minimum as well. Yes, you may enter a tenant's private dwelling unit with a 12-hour notice or by appointment or in an emergency. That is true. but it's a good practice to set up an appointment ahead of time. Tenants typically would rather be there when you come into their apartment. Just because you can doesn't mean you should. Now, if there's an emergency like a fire or a flood, you do not need a 12-hour notice to come and rescue the place. If you're convinced that there is going to be damage to the property, you are allowed to let yourself in without a 12-hour notice. Having said that, here's the procedure for letting yourself into the tenant's dwelling unit. I'm not talking about common areas like a common stairway or a common basement, but if you're going to actually go inside the tenant's dwelling unit, you must first knock or ring the doorbell, provide them a sufficient amount of time to answer based on the emergency level. In other words, if the house is on fire, you're going to immediately after unlock and open the door. But once you unlock and open the door yourself, you must immediately announce yourself. Landlord coming in. One of the largest, or one of the most common rather, complaints that I hear from tenants is that landlords and maintenance people enter into their dwelling unit without permission, without a notice, without knocking, and without announcing themselves. People feel violated. It's not a good footing to be on, landlord. And you may want to set a schedule and come in periodically. Every month for the first 6 months of the tenancy. I'm going to give you a notice. We're going to set on a day. We'll make an appointment, and I want to come walk through. Find and address code and habitability problems as soon as possible. Why? To cultivate that landlord-tenant relationship. As I mentioned, tenants who feel cared for, tenants who feel that the landlord actually is interested in providing quality, affordable housing to them are much more likely to pay rent on time in full and to take care of the property. Tenants that don't feel that way, all bets are off. And also make sure to show tenants where the fuses and circuit breakers are. They have a right to have access to the fuses and circuit breakers. Also point out where the water shutoffs are in case there's ever a leak. The tenants know how to turn off the water as to minimize damage. It's a good idea. And don't bend your rules. If you have unsavory things to talk about with your tenants, I'll just call them unsavory. Do so before the next rent payment, because after a tenant has just handed you a large stack of bills that they worked hard for, it leaves a bad taste in the mouth to then hear things that you don't want to tolerate any longer. If you have issues that you need to talk to about the tenant of an unsavory nature, talk to them about it right away, not after they just paid the rent. Be careful if a non-tenant pays the rent. By that I mean, if someone you don't know hands you money that is understood to be rent money, and you don't know who that person is, accepting that rent money is a tacit acceptance or an unspoken acceptance of that person as your renter. True story. If the tenant doesn't pay the rent, address the problem quickly. Pick up the phone. Hey, tenant, it's the 2nd, 3rd, 4th of the month. What's going on with the rent? You don't have to go right to the 5-day notice. Also, if neighbors call a complaint, act. I think I mentioned earlier, neighbors are free property managers sometimes. So you cultivate that relationship. And then use dialogue and mediation, because what you do in moderation, your tenants may choose to do to excess, right? Once you start trying to punish them, they might try and punish you, and it's just a downward spiral from there. Here's the code enforcement process, court, and the nuisance ordinance. We hear this all the time in DNS, but inspector, that's the way I bought it. It's not my fault. I've alluded to a few times already how everybody is trying to get into the rental property business. I get it, but you might be inheriting some really bad repairs. You might be inheriting some illegal alterations. Now you are responsible once you sign on a dotted line, and that's your property. DNS is not going to go after whoever actually did the work. We don't have detectives to do that sort of thing. We're just going to hold you accountable because you are now the owner. Be careful. What are the main reasons for being inspected? If you have a property that has more than 3 units, more than three residential units, dwelling units, right? So in other words, a 3, 4, 5, 20 family apartment building, those are going to get annual fire inspections. Also, commercial properties and mixed use buildings. If it's a bowling alley, if it's a bar, if it's a sign painting shop, you're going to get an annual inspection. Why? For fire safety. If there's mixed use there, if there's a tavern downstairs and an apartment upstairs, or if you have storefronts downstairs and then apartments upstairs, you're also going to get fire inspected. And just know that when the inspector is out there doing a fire inspection, they are not bound to only notice fire violations. They can notice building maintenance violations also. That is part of their job while they are there to notice and address building code violations of all kinds. Complaints, also called cases now. Complainants are anonymous. Whether right or wrong, people have the right to say anything they want about any property in the city of Milwaukee. There doesn't have to be any truth to it. Just know this, landlord, a professional inspector is going to go out and observe the property, and with his or her eyes, going to determine if there's any validity and either verify or not verify that case. So just because somebody said it doesn't mean you're in any trouble. Be aware of that. Also, while somebody's out there on a case, it might have something to do with, let's say, a smoke alarm in one unit. If they notice that there's no deadbolt on the other dwelling unit doors, they're within their responsibility to write that up. Referrals. Police officers, firefighters, social workers, if they're there doing their jobs and they notice that there's some sort of violation, let's say social worker is dealing with their clients and they see that the children are being bitten by bed bugs, they're going to make a referral to DNS. Having said that, bed bugs is not automatically the responsibility of the tenant. If you're interested in how that's determined, you can look at the Milwaukee Code of Ordinances, chapter 275-82. Alderpersons. Alderpersons make what are called aldermanic service requests. Each inspector has 1 day to respond to that. Each inspector has 1 day to respond to that aldermanic service request, if only to say that I have it on my route sheet to go inspect it on another day. They don't have to go out the same day, but they do have 1 day to respond that they have seen, and they're going to act on that aldermanic service request. Also, inspectors may self-initiate. If they see a situation as hazardous, or if they see a property that's neglected, or if they're doing a block survey, sometimes an entire team of inspectors will just go out and take a look at an entire block and write up all the nuisance vehicles and all the properties with building code issues all at once as a team. That is also a thing. In your upper left-hand corner is an example of a combination smoke and carbon monoxide alarm. It is the 10-year sealed battery type. This is just one example. There are many. Upper right-hand corner is a fire extinguisher. If you have a commercial or mixed-use building or a rooming house, you're going to be required to have fire extinguishers on every floor level within 50 feet of everybody's door and in the basement. In the lower left-hand corner, that is mostly what inspectors are looking for on their fire inspections. They're looking at the appliances. Are the boilers and the furnaces and the water heaters functioning properly? Are they venting properly? Are there excess combustibles in the basement? Does somebody have a magazine collection dating back to 1984? That could be a thing. And you must have 36 inches of clearance around those appliances because they are fuel burning appliances. Lower right-hand corner, if your building has exit signs, they must work and they must be unobstructed. Here's the wall of shame slide. Upper left-hand corner. Yes, just because you are the lord of the land does not mean that you can change the designation of your residential property and turn it into a landfill. Now, if you're having your roof replaced and you have a dumpster out front and it's actively an ongoing process, that's one thing. But if you've just decided that you're going to store a bunch of trash in your backyard, like in that upper left-hand picture, don't be surprised if DNS writes you a little love letter. In the upper right-hand picture, on a single family or duplex property in the city of Milwaukee, you are allowed a maximum of 4 vehicles, and they must be on an approved surface. Grass or mud is not an approved surface in Milwaukee. Lower left-hand corner, the main reason why fences require permits is because there are all kinds of considerations. One, the posts need to go deep enough in the ground that they don't heave when the ground freezes. Because if water gets underneath that post and then it freezes and expands, it could cause that fence to pop out of the ground and land on somebody's body or damage a car or somebody else's house or whatever. That is one reason. 2, there are height requirements. In a front yard or a side yard that's adjacent to a street, there's a maximum height of 4 feet on a fence. In a backyard, there's a maximum height of 6 feet. But if that backyard forms a T in an alley, if you understand what I mean by a traffic T, every direction for that traffic T is going to have a stop sign. But not everybody stops for stop signs. So those fences that form that traffic T are going to need to be 50% open and able to be seen through. So people that would not stop for stop signs just because they're rule followers may stop for a stop sign because they see another car coming. And that picture on the lower right, I don't think that needs any explanation. You are not allowed to store things outside that are not meant to be stored outside. That is a violation, and DNS might have something to say about it. A certificate of occupancy is required before opening a new business. If it is new construction, or if it is a property that has been shut down because it was found unfit for human habitation. In other words, if there was a sewer backup, if there was no heat in the wintertime, if, as I mentioned, if there is a building that is unsafe because there were alterations made and the structure of the building has been compromised, you may need to get a certificate of occupancy before you can occupy that dwelling and rent it to people or use it. Be aware of that. There are some hefty fines for occupying or utilizing a building that does not have an occupancy certificate. Property registration. It is the responsibility of a property owner if they do not live at the property. If you live at the property, your address is going to be listed on that property as your address, so the city knows how to get a hold of you. But if you do not notify the city how to get a hold of you, you have 15 days. If you do not do it within the 15 days, the cost doubles. The city needs to know how to get a hold of you in case there's damage or something going on at the property, or if there's a break-in or whatever. That is your responsibility. E-Notify is an option. Property registration is not. E-Notify is an option that you can opt in and be notified about things happening in the vicinity of your properties. Or it doesn't have to be your property. You can choose any address you want in the city. You can decide the radius around that property. If, 3 houses, 1 block, 6 blocks. Anytime somebody pulls a permit, or anytime there's an inspection, or anytime somebody's given a citation or a ticket, you can be notified about that. There are about 100 some check boxes, and you can decide what you want to be notified about and what you don't want to be notified about. Word to the wise, landlord of a multi-unit building. By multi-unit, I mean larger than a single family or a duplex. If it's a 3 or 4 or 5 unit building, if you register with E-Notify, you are also going to have to register each individual unit at that address. Because if you only register the street address and not the individual units, someone in one of those units could enter a case with the city, and you might not be notified about it on E-Notify. Just saying. Orders to correct are legal documents with far-reaching consequences. You may be upset about it. That does not preclude your responsibility to deal with those consequences. There are codes, and owners are responsible to meet those codes. If you ever receive an order, read everything, every single word, because you will be held responsible for every single word. And recognize that receiving orders is nothing personal. It is just inspectors keeping people safe, healthy, and alive. Because sometimes, especially when there is money involved, people will skirt certain requirements and risk death or injury in order to save money, to not have to spend money on a property. So somebody has to monitor that, and it happens to be neighborhood services. Here's an example of what orders look like now in the city of Milwaukee. In the upper right-hand corner is the inspection date. That will always be there. Recognize that if you went out there 2 days after, I see the inspection date here is January 23rd of 2017. If you went out there January 25th and you addressed some of these issues, recognize that that inspector probably had no way of knowing. They wrote their orders and they were gone. So be advised that any and every order is going to have an inspection date on it. So keep that in mind. In that oval at the top of the page, or near the top of the page, it says inspection report and order to correct condition. It doesn't say citation, and it doesn't say advisory letter. This particular type of report says, hey, here is a list of things that I found wrong with the property, and here is the time frame that you have to repair them. If it doesn't say citation, it is not a citation. Please be aware of that. People often use those words interchangeably, order and citation. They're not interchangeable, not by any means. And I also mentioned advisory letter. An advisory letter is just a suggestion. An inspector noticed something and it wasn't too serious, and they weren't multiple. Because if there's more than 2 or 3, they're going to write up an order. But if it's just 1 or 2 things that are just minor things you want to be aware of at your property, they will list them as an advisory letter. Then again, if you don't address that advisory letter within the first year or so, they're probably going to be issuing you an order. I'd like to point out that each violation has its own correct by date. Notice the red asterisk by each correct by date, or those first 2 anyway. They are different. Some of those things are required by February 2nd. Some of them are required by February 28th, and it indicates the specific part of the building, the east first floor porch. If the city requires you to replace a missing handrail on the east first floor porch, and you do it on the west first floor porch, but you fail to do it on the east, you are still in violation. Be aware of that. I might also recommend that you color code the due dates for these violations. If you have a set of highlighter markers, it is a good idea to color code by date which violations are due on the same day so you can get them all done in time. Because after they are due for reinspection, that inspector can come out at any time that it's convenient for them. They are not required to make an appointment with you. Be aware of that. It is your responsibility to maintain your property to minimum code standards. And if you don't, we have to enforce them in the way that we do. I would also like to point out at the bottom of the page, there is a correct by date with no violation. And as we go to the next page, there's a violation with no correct by date. They were separated by the page break. Please make that connection. Also, in violation number 6, there is a message at the bottom with that's all in caps. That is a custom note that was added by the inspector. They are not yelling at you by putting it in all caps. They're just putting it in all caps, so hopefully you notice it and you read it so you can act on it. Permits required. If I haven't mentioned it already, permit-related violations are the #1 reason that mom and pop landlords, by mom and pop, I mean people that have 2, maybe 3 rental properties, they're not big time. The #1 reason landlords like that end up in court with DNS is because of permit-related issues, and they're avoidable. Permits are in writing. It's all there, what's expected of you, what's required. So don't ignore if it says permit required. I will mention, if anybody's taking notes, there are 3 steps to the permit process. You must initiate the permit and pay for it. Yes, that goes up front. Step 2, you must have a qualified person do the work. It may be you, but landlord, it most likely won't be you. The only exception being if you live at the property or if it's your own property, right? If it's your own single family property, you might be able to pull your own permits. Or if it's a duplex where you live and it's the unit where you live, you may be able to pull your own construction permits. But even if you're an electrician or a plumber, you're not allowed to pull your own plumbing or electricity permits. Sorry, that was step 2, getting a qualified person to do the work. Step 3, and this is the one that lands people in trouble most often, you must call and arrange for a reinspection. On the permit itself, it's going to give you a name, a number, and an email address of somebody you need to contact to come out and take a look at the work that was done in order to ensure that it was installed or done correctly. Be aware of that. At the end of the list of violations is always going to be the inspector's name who wrote the orders, their desk number, their email address, and the hours and days they work. If you need to contact them, that is how you do it. Be advised, not all inspectors have the same schedule. You also have a right to appeal. It says you have 20 days. The Milwaukee Code of Ordinances requires that a written appeal of this order be received within 20 days of the service of this order. Now, if you do not have your property registered correctly, if you do not have it registered with the city correctly and you live somewhere else and that mail doesn't get to you for 17 days, that means you have to, quick like a bunny rabbit, get that appeal in the mail in order to make it in under that 20-day deadline. Also, there is tenant rent withholding, which I briefly mentioned earlier. Tenant rent withholding is when there are violations, with the exception of exterior paint, that are in violation at the time of re-inspection. The tenants are allowed to go on what's called rent withholding, whereby they still have to pay all of their rent in full on time. They're just not paying it to you. They're paying it to the city. And the city is going to tack on a fee to open that account, a fee every month that account is open, and then another fee to close that account. You may draw from those funds as they accumulate if you need to pay a contractor for work to be done, or if you have receipts for materials in order to get those violations taken care of. But you must provide proof before we disperse those funds. And then the reinspection fees, if I haven't mentioned them, $203.20 for the first one, $406.40 for everyone after that. And those can pile up. Those will go on the tax bill. Everything with the city of Milwaukee, those that get in line first get served best because we can. It's not punitive. It's not malicious. It's just, if we don't have time to find a Spanish or a Hmong translator for you, and you came to us 2 days before your court date, we're going to do what we can, but ultimately that's on you. If you need something from the city, those that get in line first get served best because we can. This is what the rent withholding form looks like. And this is where an inspection comes out, or an inspector rather comes out to do a reinspection, and violations are still there. Again, if all the violations are taken care of, it doesn't cost you anything in reinspection fees, and there's no option for a tenant to go on rent withholding. Some specific information that you're going to want to pay attention to if you ever receive orders: the locations and the specific violation. By that I mean, if the order is ordering you to replace a missing handrail and you decide to rebuild the entire porch, you're going to need to pull a permit. You don't need to pull a permit to replace the handrail like we told you to, but if you take it upon yourself to rebuild the entire porch or to build an entire new set of stairs, that is different, and that is still going to require a permit. And notice those correct by dates. Please don't get confused. I mentioned the highlighter marker system. Use whatever system you want, but know whatever the set of orders that we send to the address that you tell us to, those are yours to keep. You can mark those up to the extent that you want. And it's not a bad idea, once you receive those orders, after you have read them completely, maybe even twice, to go outside and take a look at what those violations are. See if you can understand them. Make notes for yourself in the margins of the orders. I'll tell you why in a minute. After you've read them carefully, call that issuing inspector. Let them know, hey, inspector, I received your orders. I'm going to get on these right away. If I have any other questions or concerns, I'll let you know. What do I mean by that? Let's say that one of the violations is you have to have a window replaced. The entire window frame is shot, and one of the panes is broken, and you're going to put a new window in there or a new roof. Sometimes it's not so easy to get a contractor to do that stuff. And if you were given, let's say, 60 days to get that work done, and you have 50 days left, but you called 10 contractors and only one of them called you back, and they said, hey, I can't even do it for 70 days, you very well might be able to get an extension from that inspector because you got on your horsey right away. People who wait till the last minute often end up doing it to their own hurt. So call that issuing inspector, and then if you have questions or if you need something, let them know right away. I'm going to say it again. Those that get in line first get served best. If you waited till day 87 of your 90-day order to ask for an extension, and now you're saying that you can't find a contractor, that's partly your negligence, and at the very least, it's going to cost you a reinspection fee. You are allowed one meeting to clarify. You are allowed one meeting with that inspector at the property to ask specific questions. Hey, I don't understand what you meant by blank. Can you tell me exactly which part of the siding on the north side of the house you're referring to as defective? Because it all looks good to me. You are allowed one meeting like that. Also, ask about permit requirements. They're that important. And then start the work, especially those of you that are buying tax foreclosure properties. It's not that uncommon. People entering the landlord business, the cheapest properties to get are the city tax foreclosures. Well, those are also the most abused properties. Not only were they let go, the owner stopped paying taxes for 2 years because the city does not start the process to take that property away from somebody until they've fallen behind 24 months in their taxes. But imagine what sort of repairs did a landlord that has that sort of approach to their business. Imagine what sort of repairs a person like that does. Trying to go behind somebody who did a repair improperly the first time is much more difficult and time consuming to come behind and then have to do a good job and produce a good finished result. So be aware of that. Start right away. And if you need extensions, let us know right away. We might be able to do it for free. At some point, an inspector is only allowed to give you one free extension. So bear that in mind. Key phrases are permit required. I think we've mentioned this a few times. If it says that you must have a permit, that inspector is not allowed. Hear me. That inspector is not allowed to okay the work that was done until a permit was pulled, the proper person did the work, and then a reinspection was done. Those 3 things are required. Until then, that inspector cannot okay that violation on their order. So just be aware of that. And make sure that you have the proper permits before you start the work. In addition to permits, you may need the services of an architect or a designer. By that I mean, sometimes there are jobs that go beyond just getting a permit. You might need to have somebody design a solution for you. Case in point, I did an inspection one time where somebody rented a property to somebody and the beam holding up the house was severed in 2 or 3 places. So not only do you need a permit to replace the beam that holds up the house, but imagine there has got to be a proper way to hold up the rest of the house while you remove the defective beam and install a new one. Yeah, that's not just anybody can do that. So be aware. In addition to permits, you might need to call a professional too and have them design a solution for you. Here are the big 3 permit items: plumbing, electrical, and construction. In an owner-occupied, hear me, single family, you may pull your own construction permits on many things. You may even pull your own plumbing permits if you want to, except for a water heater. But be advised, on your rental property, if you do not live there, you do not get to pull your own construction permits. And even if you do live there, you do not get to pull your own plumbing or electrical permits at a rental property. Be advised, people get in trouble with this stuff. If you have a question about whether something needs a permit, if you go to milwaukee.gov/home, that's the City of Milwaukee homepage, scroll down to the Find It Fast menu, click on the See More button. It will drop down a longer menu now, and it includes licenses and permits. If you click on licenses and permits, that is a link that will pop up, and there'll be a long list of things that yes, no, or maybe require a permit. And there will be a phone number to call. Even if you don't need a permit, you may notice the second one, asbestos for a single family or a duplex. Do you need a permit? No, but you still want to call and find out how to do it safely. I already mentioned the right to appeal. It's very important, but recognize it's on you to do it within the time that you are allotted, and you must have a legitimate appeal, and it must be in writing. You can't just write appeal because you're angry. This is a perfect example of it's just a rental repair. Notice how poor that looks. Codes do not have separate codes for it's just a rental. They don't have lower standards for it's just a rental. If you're going to replace crown molding, replace it with crown molding. Don't just cut a chamfer on a 2x4 and paint it to match and then spill tar on it and nail it up there. Inspector does not have to accept this repair, quote unquote. Every paint violation is going to include the phrase paint applied in a workmanlike manner. Just because things may not say done in a workmanlike manner, rest assured, every single thing that an order is ordering you to do expects you to do it in a workmanlike manner, which means by definition that the finished product looks like somebody who knew what they were doing did it. Here's an example of non-workmanlike paint job. Oh, rather than scrape and sand and putty and maybe caulk some of those voids, I'll just go with my power painter and just paint over bad paint with good, new, fresh paint. We don't have to accept that because it's going to flake off and peel off in no time. As you can see in that upper right-hand picture, on the left edge of that red circle, you can already see that there's the other paint showing underneath. It's not going to be long before that stuff flakes off, and it's a waste of your time and money, and it's a waste of perfectly good paint. So do it in a workmanlike fashion. If you do not know how to do drywall, there are alternatives. You can either hire somebody who does. You can go to YouTube or a library and you can study how to do drywall repair. Yes, there are alternatives. Doing a job like this because to you it's just a rental does not pass go, does not collect 200. I was just kidding. We don't pay you 200 anyway. Oriented strand board may be used for exterior applications, but be advised, OSB is not rated for exterior use when it's in contact with the weather. You may use it for decking and for sheathing on exterior applications, but then it must be protected by ice and water shields and or tar paper and then roofing shingles or a vapor barrier and then approved siding material. It cannot be exposed to the weather even if you paint it, as you see in the picture below. Fence repair, I don't think I have to say anything about the fence repair on the left. That is a fail. The one on the right is a pass. If you have rotten or damaged fence boards, sure, you don't have to replace the entire fence. You can do it piecemeal, but the finished product has to look like somebody who knew what they were doing did it. And the one on the right applies. Your number one enemy is water. Water never sleeps. Water is always responding to gravity and trying to find its lowest point. That makes it very predictable. It also makes it very destructive. So be advised. If you have water issues, get on them right away because they don't get better, they get worse. And number two, we recommend that you do repairs yourself or that you hire someone. Letting tenants do repairs in exchange for rent, a discount on the rent. Our offices have noticed over the years that often ends up in turmoil. You don't want to go that route because if the tenants do a poor job, you still have to get somebody to do the work. Meanwhile, the tenant is expecting a discount and that can be awkward. You're better off just avoiding it altogether. And point number three, also because our offices encounter this so often that a landlord will say, well, this trouble started when I put this tenant in there that I didn't screen because my place was empty for a month or two or three. If you don't have a qualified tenant, maybe you're charging too much rent and you're not attracting enough people, or maybe you just need to wait a little bit because time has shown that putting a tenant that doesn't belong in your rental property could be asking for trouble, and it's not always immediate or automatic getting rid of tenants like that. So you're better off losing a month or two of rent than putting somebody in your property who might do more damage than they're worth. Okay, those plastic rain diverters, those are allowed only after the water has gotten down to grade. Grade means the surface of the earth in any given place, whether it's grass or wood chips or a garden or concrete or asphalt or brick pavers. Only once you've gotten that water through the gutter and downspout system, once it's gotten down to grade, can you use those plastic diverters. And if you ever wondered what the requirements were for how you need to drain the water from your gutters and downspouts, please take a look at this. This is directly from Milwaukee Code of Ordinances, Chapter 225-4-A-1. I'd like to draw particular attention to the last sentence. Those of you that have gutters and downspouts on your garage that drain directly into the alley, it says the discharge water shall not create an icy condition on any pedestrian walkway. Yeah, alleys are pedestrian walkways. You are not allowed to just drain your water into the alley. Connecting downspouts to the receiver and seal the connection. Now, there is a City of Milwaukee has asked everyone from Capitol Drive on the north to Oklahoma Avenue to the south, from 60th Street all the way to the lake, that if they can, to disconnect from the storm sewer, because it's expensive and difficult, and we need to replenish our water table, and there's a number of different reasons. But just recognize, if you do get to stay connected to the storm sewer, it must look like the picture on the right. Because if it looks like the picture on the upper left, rats and mice can crawl out of that and run around your neighborhood, and we don't want that. You may also use an option like on below left. You can see that storm sewer receiver is covered with, looks like mortar, and they have one of those fold away when it's not in use rain diverters. So if rain pressure builds up in there, it unfolds and it turns into a little sprinkler. When the rain pressure disappears, it rolls back up and disappears. Concrete repair. If you are repairing concrete, you must use a concrete bonding adhesive while the concrete is still wet. When you're mixing the concrete, you add this bonding adhesive, and then and only then will new concrete bond to old concrete. Otherwise, as you see in the picture on the above left, it's still wet and dark and it's already breaking away. Lower right picture, there's a few things I want to point out. One, that is a reasonably acceptable concrete repair job of that second step. I'm okay with it. Well, second and third step, it looks like. I can live with both of those, but be advised, that is a service walk stair that has more than 3 risers. Risers are the vertical portion of the step. Treads are the part you step on, but there's more than 3 risers. So technically, that stairway needs a handrail on the right side as you descend the stairs. If it were a porch, you would need handrails on both sides because it has more than 3 risers. Oops. Tuck pointing. Tuck pointing is seemingly a lost art. If you don't know how to do it, again, just like with all the other things we said, these things must be done in a workmanlike manner. If you're not capable of doing that yourself, hire somebody or train yourself. Get the training that you need, but just smearing mortar on the wall is not going to complete that violation for you. The picture on the lower right is an example of reasonably okay tuck pointing. It doesn't look professional, but it's good enough. It's all we're asking. Guardrails. Guardrails are extremely serious safety measures, right? Guardrails keep people safe, healthy, and alive. And the spacing on your guardrails between the balusters and the posts and the caps on above must be no greater than 4 3/8 inches in any direction. In other words, if you had a 4 3/8 inch diameter sphere, that it would just barely be able to slide through any space on that guardrail system. Having said that, please don't use horizontal balusters. Technically, they're allowed, but please don't. As you notice in that upper right-hand picture, that's a 2nd-story porch. Imagine that you have a couple of 10-year-olds running around and playing tag up there, and all of a sudden they notice, oh, here's a ladder. And they might decide to climb up those horizontal balusters, and that could end not well. Please don't do that. Technically, it's allowed. I'm asking you not to. Picture on the left, also be advised, every part of a guardrail system, that means the posts, the cap, the balusters themselves, must be able to withstand 200 pounds of applied force in any direction. Lattice does not meet that threshold. Lattice may be used as skirting around the bottom of a 1st-story porch to keep vermin and stuff out from nesting and whatnot underneath the porch, but it may not be used in a guardrail system like that. Similarly, handrails, there are rules. In the picture on the left, the guardrail on the right, the 2x4 laid flat with the big red circle with the X through it. You are not allowed to use 2x4s as handrails, laid flat like that. Yes, I'm aware that at least a few people in our city have gone that route. That does not make it okay. On the left side of that picture, you see that they have that 2x4, and then they attach what we call a closet pole. It is a round pole with a flat bottom. It makes it easier to attach brackets, and they attached it to that handrail. I just want to point out to you, while the one on the left is graspable, because the 2x4 technically is not graspable. A lot of people could not wrap their hand around that and slide it down that 2x4 with any sort of control. The handrail on the left is graspable, but those points sticking out in a space like that are also a safety hazard. They could catch someone's shirt sleeve or their purse strap and could cause an unsafe condition. So be aware of that. You want to cut those off at a 45 and then have them do what we call die out. It makes a 90-degree turn and end, so you don't have those poles hanging out into space. Picture on the right, surprisingly enough, has only 3 risers. So it does not require handrails. And it's less than 24 inches from grade, grade in this instance being wood chips. So it doesn't have to have a guardrail around there. Personally, if that were my property, with the kind of weather that we have in Wisconsin, I would have handrails at least on the stairs, but technically they're not required in this instance. If your tenants are paying the heat, you, the landlord, are required to provide weather-tight dual pane windows, single pane windows with storms, or you must ensure that plastic is installed on the inside of the building. Plastic, under no circumstances, is allowed to be installed on the outside of windows like that. It's very noisy and it's too easy for people to poke holes in there, and then it's even more of a sound nuisance and it just doesn't work. So do it on the inside. Bars on the windows. Bars on windows within 10 feet of grade. By that I mean at the bottom of that red circle, you have that windowsill. If that windowsill is within 10 feet of the earth below it, those bars must be, this is the standard for bars on the windows within 10 feet of grade. They must be openable from the inside with one motion, without any special knowledge or a key. So be advised, bolt-on bars on the windows are a death trap. Imagine if that picture on the left is a first-story bedroom window and a smoke alarm goes off in the middle of the night and the tenant living in that room goes to try and exit through the hallway and they can't because the door is hot. So now they have the rest of their lives to figure out a way to get those bars off that window before the smoke or the fire gets them. The examples on the right are examples that you may use. Notice that one on the lower right. It has a deadbolt that is keyed from the outside, but is not allowed to be keyed from the inside because it would be too easy for somebody to accidentally grab that key from the inside, and now it's a death trap again if it's locked closed. It must have a lever on the inside in order for that bottom right system to be used on a window within 10 feet of grade. Landlord, your premises must be maintained in a dust and erosion-free manner. If your tenants kill the grass, you must come up with a solution for the tenants killing the grass. Leaving it dirt is not an acceptable solution. You may plant sod, you may put bushes like we see in the lower right-hand corner and then put down wood chips. You can pave it with asphalt or concrete. You have a lot of options, but you cannot just leave it a mud pit. And saying that my tenants did it is not an acceptable excuse. If your single family or duplex has a gravel drive or a parking surface that has been there prior to 1973, you must maintain it to keep it. By that I mean, if it looks like the picture on the right and an inspector comes by and issues an order, you have now lost the right to have a gravel parking space. The city would rather not have gravel parking spaces. But if you have it prior to 1973 and there's no weeds or grass growing in it, there's no ruts, there's no standing water, and the gravel is not washing out into the public way, you are allowed to keep it. But again, it's contingent upon your maintenance of that parking spot. Now, if you receive orders from the city, there's 2 ways you can go about it, the easy way and the hard way. The easy way is to just cooperate. Call the inspector, ask what you have to do, take care of business. There will not be any punitive fees if you get the work done in the time that you were given and it's done to the minimum code standards. There are no additional fees. It'll only cost you the time and the effort and whatever it costs you to hire somebody to do the work. However, if you go the other route, you may be sent to court, or there may be reinspection fees involved. The reinspection fees will be outlined in every order that's issued. Again, if the work is done by the compliance date and it's done satisfactorily, no reinspection fees. I might also mention, if you have, let's say there are 10 violations on the exterior of your property, and you're not financially able to take care of all 10 of those in the time that you were given, the strategy you want to employ is to get at least numerically half of those violations done in the time that you were given. Then when it's reinspected, you will get a reinspection fee of $203.20 for the first time, and it will be extended usually half the original time. You can keep doing that as long as you get half of the violations that are still outstanding done in the time that you were given, because you will keep getting extensions with those reinspection fees. If you end up going the other route and you take your chances going to court, failure to comply with that order, court action is necessary, because that inspector doesn't have any other means to try and get your attention, to try and get you into compliance. A court date will be set and you will be summoned to appear before a judge. If you are summoned, go. When you get before the judge, I will just make this quick. You will be given 3 plea options. I recommend that you use option number 3. Plead no contest and ask for an extension. Because if you plead guilty, well, you just accepted your guilt and you go to the next step, which we'll talk about in a minute. If you plead not guilty, you might get away with it, but it doesn't really benefit you anything. Even if you're plead not guilty and then you're found guilty, you go to the next step, which we're going to talk about in a minute. But if you plead no contest and ask for an extension, all things being equal. In other words, if you do not have a history of poor property maintenance, obviously there are notorious landlords who have worn out their welcome and they don't get the option of an extension. But if you are not one of those, you will most likely get a 60-day extension, and that would allow you 2 more months to call in every favor that you have and use your credit cards and make sure that you take care of that business so you don't get jammed up in court. You will get that 60-day extension, but then after that, then there's going to be a reckoning. And by that I mean, please be aware, a court inspector, not the original inspector from the original district, whether it was a residential or a commercial inspector, there are only 2 inspectors for the court section. One for the north side, one for the south side of Milwaukee. Be aware of that. You will get a letter notifying you that your orders have been sent to court. This is your new inspector. This is his or her name or their name, and these are their hours and days of operation. You must call that inspector 10 days before your court date to arrange for an interior inspection if there were interior violations that you needed to fix. Let me say that again. It doesn't matter how well you did those repairs. If you do not arrange for an appointment to get that inspector in there before court, first you call the inspector, you make the arrangement, then you notify your tenant, you make the appointment, and then you show up. Here's why. It is not uncommon for tenants to have an appointment with a court inspector to come reinspect violations on the interior of a property, and they forget or they don't care because it's not their skin in the game. And then if the inspector doesn't get in, when you get to court, you are guilty of not having repaired those violations because the inspector could not see with their own eyes that you had in fact taken care of them. So make sure you call 10 days before, arrange with the inspector first, and then you notify your tenant, and then make sure you show up. So if the tenant's not there, you can let that inspector in because you have an arranged appointment ahead of time. It meets that 12-hour notice requirement. Now, if the inspector gets in there and finds out that everything's compliant, fine. You go to court, you pay the court costs, that's it, the end. That order gets stapled and filed. But if you're found non-compliant, if there's even one violation left, you're going to get hit for $100 for each violation, plus the court costs. Now, those court costs and those court fees for the violations, they go against you personally. You may recall I mentioned reinspection fees go against the tax bill. So you won't pay that, or whoever owns the property at tax time is going to pay those at tax time. But no, that first order now gets closed. It gets stapled and it gets filed. But it's not over if there were any violations left. Now, if there were no violations left, like I said, if it was found compliant, the end, boom, you pay your court costs, that's it. But if there were any violations left, it's not over. And what happens is the inspector from that district is going to be notified that you were found, that order was found non-compliant in court. And they're going to be told to go back out and reissue new orders. It's not going to say go back out and issue those original violations. It's going to say go issue new orders. Whatever violations that inspector sees on that second inspection, they're going to write up. So be aware of that. First of all, the way to avoid all this is to maintain your property properly. Let me say that again. Good property maintenance is the best way to avoid all this. But if you don't, here's what's going to happen. Inspector's going to go out. They're going to issue a 30-day order this time, 30 days. And then every month, just about every 30 days, somebody is going to go out there and reinspect those orders, the second set of orders. And if every single violation on that second set of orders is not found in compliance, you're going to get hit for a reinspection fee, $203.20 the first month, $406.40 every month after that until whenever, until you sell the house or go bankrupt or whatever. Again, the path of least resistance is to just respond to the orders and make the repairs. This is what we call flying the blue flag. If you really want to get an inspector's attention, just go ahead and fly this blue flag for a few weeks. Now, if there's a pallet of shingles in the front yard and a couple rolls of tar paper and a dumpster at the curb, and we can see that you're in the process, actively in the process of replacing that roof, that's one thing. But if this is your solution to a bad roof, expect the DNS is going to come and issue orders. Now we're going to go to the City of Milwaukee Nuisance Ordinance 8010 in the Milwaukee Code of Ordinances. It is the unreasonable, unwarranted, and or unlawful use of property which causes an inconvenience or damage to others, either to individuals or to the general public. Recognize, landlord, you are being held responsible for this to some extent. What do I mean? All of these violations that you see before you written in black, this slide, the next slide, and the third slide, all the violations written in black are considered minor violations. That means any 3 of these violations that occur in any single month, you will be sent a letter from the local police captain. We'll explain more about that in just a minute. Nobody's blaming you for anything. We're just notifying you that for some reason, your rental property is a magnet for nuisance activity, and you're being invited to be part of the solution. I want to emphasize that. It's not punitive yet. You're just being invited to be part of the solution. If you cooperate and comply in the time that you are given, there will be no punitive measures taken against you. If not, it could end up costing you a lot. We'll talk more about that in a minute. I just want to point out to you that loitering, how is loitering's a landlord's fault? It's not your fault. Nobody's blaming you. The city is just saying that your rental property with tenants that you allowed to go in there, for some reason, they're a magnet for nuisance behavior, loitering being one of them. Public drinking is technically drinking while you're standing on the sidewalk or on the curb or on the street. If you're standing on the grass, you're okay. Just said all that to say, these are things that happen all the time, and you're being invited to be part of the solution. Now, you may recall I mentioned all of these violations in black are minor, and any 3 of these in a given month, and you'll receive the letter. But any 2 of these blue ones, keeping a place of prostitution, possession, manufacture, or delivery of controlled substances, gambling, crimes against life and bodily security, or crimes involving illegal possession or use of firearms. These are major violations. Any 2 of these major ones in a calendar year. The other ones are any 3 in a month. The major ones, any 2 in a year. And you're going to get a letter from the local police captain. If your tenants' children are calling 911 for fun, that is a violation. Sale, discharge, or use of fireworks. These are things that go on all the time, right? Just be advised, landlord. If you cooperate and you follow through, you will not be charged punitively for any of this stuff. But having said that, once MPD identifies your property as a nuisance property, in other words, there were complaints made or patrolling officers substantiated 3 of those minor violations in any given month, or 2 of those major ones in any given year, your point number 2, MPD is going to send you a nuisance designation letter. They're sending you a letter notifying you, landlord, that your property, for some reason, is a magnet for nuisance activity, specifically this, and it's going to list all those details. It will include your appeal rights. Now, at this point, you have a choice. You can either comply or you can not comply. By that, I mean, you can comply by coming up with an abatement strategy. Hey, police officer, what if I put up a fence and motion detector lights and a no loitering sign? And what if I showed up unannounced at various times and just drove by the property to see what's going on there, and then I logged it on a piece of paper? If the local police captain says that's okay, cool. That is what we call, that is your abatement plan, right? If you respond with a written abatement plan and the police agree to it, great. You have 45 days to implement it. But if you do not respond with a plan, if you respond within a plan and you don't implement it within 45 days, or if you appeal and lose, obviously if you appeal and win, you're off the hook. But if you appeal and lose, or those other 2 options, now you go to what's called billing stage. And that means whenever the police come out to your property for nuisance activity, you are paying for those police to be there. You're paying their paychecks while they're at your property. Yes, it can get kind of costly. So number 2, billing stage, only happens if you don't cooperate and follow through. If you cooperate and come up with an abatement plan and you implement it within 45 days, you will not be charged for the police coming to your property. You are doing what we ask you to do. However, if you are billed 3 times, now you are eligible for a chronic nuisance premises citation on top of paying for the police. At the moment, it's a $3,200 citation. If the Common Council decides to raise or lower it, it will change. Otherwise, at the moment, it is $3,200. So you decide. You can either be part of the solution or you can roll the dice, and it could be very, very costly. Again, this is just review. That forfeiture range is anywhere between $1,000 and $5,000. Currently, our Common Council in Milwaukee has decided that $3,200 is an appropriate number, and that's what it's been for a while. Some final thoughts. The activity must be substantiated. Just because a neighbor keeps calling that there is nuisance activity going on at your property, if when the police show up, they don't substantiate it with their own eyes and ears, you don't get in trouble for it. You don't get the letter from the police. But if they do, now you have to act. Also, it will not be used, it cannot be used for anything related to domestic violence. And in those situations where there's domestic violence, eviction is probably going to be part of the solution. Having said that, let's look at that last point at the bottom. Retaliatory eviction is illegal. By that, if you have a 4-family building and little old man on the first floor keeps calling in the nuisance activity because the people upstairs are running a gambling operation out of their house, and they have prostitutes that are working out of that upper unit, and they're firing off their firearms at midnight, and they're selling loose cigarettes, and they're doing, there's a long list of things, right? You are not allowed, even if that person downstairs who's calling in all this activity, even if they're on a month-to-month, you are not allowed to give them a 28-day notice just because they are calling in the activity, because that will be perceived as retaliatory, and the police will come after you with a citation. True story. And lastly, eviction alone is never going to be an acceptable abatement plan. There must be more to it. You have to be more creative than that.